Hi, I'm Brian Stetton, Policy Director for the Treatment Advocacy Center, and we're doing the next in our series of videos with folks who are involved in AOT programs around the country in various capacities. And today I'm very happy to have Nicholas Schrantz, who is the probate monitor for the AOT program in Butler County, Ohio. Thanks for joining us today, Nick.
Thank you, Brian.
Sure. So tell us first just a little bit about Butler County. You guys, I guess, are a county right outside of Cincinnati. It's sort of in that area. Is that right?
Butler County is the county north of Cincinnati. It's a county that has two older industrial cities in it. It has a college town where Miami University is located, and then a significant rural population and also a significant suburban population with very fast-growing and up-and-coming suburbs. So
Gotcha.
It's got a combination of a lot of different demographics.
Mm-hmm. Sounds like it's a pretty diverse place. And, you know, Ohio, just as you know, a couple of years ago, revamped its AOT law to make it more clear that there is even an opportunity to do AOT. But you guys were really way ahead of the curve, and even under the old law, which some found confusing. You've been doing this quite a while. Is that right?
That is correct. I've been doing my role as the probate monitor for over 8 years now, and certainly my role existed prior to that. But at least I know for certain in the last 8 years we've been very aggressive in using the outpatient civil commitment statute to assist people in their treatment outside of the hospital setting.
Gotcha. And is outpatient civil commitment the term that you generally use? Do you call it AOT, or is there some
Generally,
other?
the two terms we would use would be outpatient civil commitment or what we call community probate.
Gotcha. So let's talk a little bit about, before we get into what your role is, about how many people are you guys serving at a time typically?
On my caseload now are 95 people under a civil commitment order by the Butler County Probate Court.
Okay.
Seven of those 95 are currently at our state hospital.
Got it.
Several, 1 to 3 at any given time might be in an inpatient setting at an acute care hospital. So they would need readmission to the hospital. We would use a court order to get them there and keep them there. And then the other 90 or so, 85 to 90 or so, are in the community on the community probate.
Right. So the few that are in the hospital are people who had some trouble on an outpatient basis and it needed to be rehospitalized. Is that how they went up there?
That is correct.
Okay. So let's talk about your role in the process, because I think it's really important and unique and something that folks around the country who want to start AOT programs should really consider replicating. As the probate monitor, how would you describe your essential role in the function of the AOT program there?
My role would be to be a liaison between the probate court, the mental health board of Butler County, which provides a lot of the services that people receive, and where the assistant prosecutor who prosecutes the cases is housed. And then, of course, between the treatment community, the people who provide the direct care to the residents, or to the folks that are under community probate orders, and then also to the variety of group homes and other housing situations that we have in Butler County where people under community probate live.
Okay.
And my job is to liaison and link all those different services.
I see. So do you appear at the initial hearing where a person is put under AOT? Do you have a role in that hearing? Are you appearing and talking about what kind of services the person will receive?
I attend the initial hearing because it's a legal process and I'm not a lawyer. I don't have any active participation in the actual hearing. Mm-hmm. But the moment the hearing ends, I meet with the probate respondent to discuss what the hearing entailed and what would be next. I usually meet with family if family is present at the initial hearing. And then because these hearings take place at hospitals, I then meet with the hospital social work staff to immediately start discussing what treatment they may already have in place, what housing they may already have in place, or what our Butler County community can offer them for both treatment and housing perspectives.
Okay, so it sounds like at that point you're developing a treatment plan for the person or working with their care team to develop a treatment plan. Is that right?
We try to immediately after the hearing, yes.
Okay, so that's interesting. I mean, there are jurisdictions where the treatment plan, there are certain state laws that require that the treatment plan be presented at the hearing and that's part of what the judge is going over to make sure it's all appropriate. But it sounds like you guys do it differently. You have a hearing that's simply about the person's eligibility for AOT, and you develop a treatment plan immediately after. Is that right?
That is correct.
Okay. So the person gets their plan. I assume that you're involving them in developing it in terms of what they're interested in having and what works for them and where it's convenient for them to go for services, etc.
Yeah, yes. The first person I meet with after the hearing is the respondent themselves.
Right.
Now, sometimes the respondent themselves is too agitated, too upset, and does not want to participate and talk with me afterwards.
Right.
So then I may go back to the hospital setting afterwards to discuss with them. It just depends on the situation. But if the respondent is amenable, I will meet with them immediately after the hearing.
I see. And in those cases where you find the person agitated, what is it specifically they're upset about? Is it they don't like that they've been put under this court order?
Well, the reason they have the hearing initially is that they have stated that they don't want to be at the hospital setting. The treating physician deems them danger to themselves or others are unable to care for themselves. They want to leave. They have a defense attorney defending them and defending their goal to leave the hospital setting. And at that point, the court is ordering them to remain at the hospital setting. So they may be upset about that decision. Now, not all people are. In fact, a fair number have been at the hospital for 6 or 7 or 8 days by that point, have started to respond a little bit to treatment, and are amenable to discussion afterwards. Mm-hmm. But there are those that are not.
Are you saying that they're ordered to stay at the hospital just until the outpatient plan can be developed? Is it just sort of a, sit tight while we put together the services you're going to need? Because you are talking about an order for the person to receive services in the community, right?
In Butler County, the person at the initial hearing is ordered to the hospital setting until the treating doctor at the hospital deems them ready for discharge. Okay. The court does not determine that discharge date, and the court does not determine the discharge placement. The hospital does.
I see.
In Butler County, it is assumed that immediately after your hospital discharge, you're automatically flipped from inpatient probate status to outpatient or community probate status.
Gotcha.
The only way that would not happen is if the treating psychiatrist at the hospital setting used our standard written report to send a report to the court saying that person no longer needed outpatient probate. That's happened only once in my 8 years.
Interesting. So, in other words, the person is put under an order that immediately directs them to receive inpatient treatment, but contemplates that when it is appropriate, they will be released into outpatient care, and they remain at that point under court order.
They do.
Okay. So is the judge at any point telling them, listen, when you get out, there's going to be an expectation that you adhere to the outpatient plan that your treatment team is going to put together for you? Do they ever sort of receive any kind of direction from the judge on the fact that there is going to be this continuing obligation even after they get out of the hospital?
Yes, at the end of the hearing, the judge he or she will make their determination. They will let the entire room know what that decision is. Mm-hmm. They then will discuss with the respondent the fact that they do expect them to work with me and to work with their treatment team to follow an outpatient treatment plan. And then they give them the date of their 90-day hearing. So within 90 days of the initial hearing, they have a review hearing at the courthouse in which their situation can be reviewed, and their treating doctor in the community at that point recommends whether they remain on outpatient civil commitment or whether it should be dismissed. But that information is given to the respondent by the court at the initial hearing.
Got it. Okay. So getting back then to your role. So you have a person now who's been ordered to receive inpatient treatment. You know that that's going to be converted to an outpatient order at some point. So you're basically getting ready for that release date from the moment that the person is admitted as an inpatient and trying to get those services aligned for them?
Yes. So I have relationships with the different hospital social workers. I have relationships with the different treatment agencies in Butler County. Some of the folks who are on a civil commitment already have treatment. It's just that they ended up in the hospital and then need the court order.
Right.
Some of them are new to the system or haven't had treatment in years. And then I work with the hospital staff to get them set up for the most appropriate treatment provider based on their insurance status, where they live, etc. Butler County has an extensive set of group homes where some of our folks live. I'll work with the housing coordinator who coordinates those different group home placements to get them immediately assessed at the hospital. So hopefully, if they need a group home, a bed is available. So they go straight from the hospital setting to the group home setting.
Okay. And who exactly do you work for? Are you an employee of the county mental health department or the court?
I'm an employee. I'm an employee of a private community mental health agency. So I am not a county employee for either the mental health board or for the probate court, but I work for a private mental health agency, which is one of several that provides treatment to Butler County residents at the community mental health level.
I see. So this agency that employs you essentially has a contract with the county mental health board to provide these liaison services for AOT folks? Is that how it works?
That is correct. My agency contracts with the board to be the probate court monitor.
Right. Okay. So once a person is released into the community from their inpatient commitment, describe what your role is in terms of keeping tabs on them and making sure that they are adhering to their commitment as an outpatient.
I set a goal of meeting with people within the first 2 weeks after their hospital discharge to meet with them at whatever housing situation they have, to meet with them and see how that's going, how their outpatient treatment is going. For people who get out of a hospital, by the time I see them, I've likely had contact with a group home if they've lived there, with a family member if that's where they live, and with the treatment provider that is providing the outpatient treatment. But my goal is definitely within 2 weeks to go see them after any hospitalization.
Okay. And do you also meet with their outpatient treatment team at some early point?
I will meet with their outpatient treatment provider face-to-face if they're at a group home, because we have at least monthly treatment team meetings at the group home that I attend all of those meetings.
Okay.
I have phone contact with most of the case managers on a fairly regular basis, especially when things aren't going well or when someone is new to the probate system. And then I also receive a monthly report from everyone who receives case management services. They send me a monthly report that I review and then send to the mental health board and the court. So that's a monthly report that keeps the court and the board up to date on each person and myself.
Okay. And when you meet with the patient, is there are the treatment providers involved in that meeting at all, or are you meeting completely separately with the patient and with the providers?
It just depends.
Yeah. So there are points where you bring everybody together?
So sometimes I meet with them individually. Sometimes if it's necessary, I'll meet them and have the case manager and other parts of the treatment team present. It just depends on the situation.
Right. Okay. So you have that initial meeting. Do you tend to find people you mentioned how they are sometimes irate when they are initially committed as an inpatient. Do you find that people resent the fact that they continue to remain under court order as an outpatient, that they don't have complete liberty to make their own outpatient treatment decisions, or do you find that people generally at that point are in a better frame of mind about their obligations?
Often by the time I see them, they're in a little bit better frame of mind. And there are many who have started their treatment at the hospital setting. But generally by the time I meet with them for the first time after the hospital setting, they're generally fairly amenable to meeting with me and talking about treatment.
Okay.
They may not be happy about the court supervision. They
Right.
may say they don't want to get treatment. They may say they don't want to live in the group home. But generally, they're moving forward in treatment at that point.
Okay.
Maybe not voluntarily, but certainly responding to the court order.
Right. So at some point, there's going to be another court hearing, right? I guess when you get to the end of the term of commitment, you're all back in court. Is that right? And you're there to report
Yes.
on how the outpatient treatment is going?
Yes. So after the initial hearing at the hospital, we have a review hearing within 90 days.
Mm-hmm.
At the 90-day mark, I get a report from the treating psychiatrist that I submit to the court. In addition, I create a probate monitors report for the court that reviews everything that really has happened with that person since the court last saw them at the hospital setting. I record where they live, who their treatment provider is, if they've had any rehospitalizations, if they've had any legal troubles, and then I provide a synopsis of my contact with the person, what the treatment team's contact with the person has been, and what other supportive people's contact with that person has been.
Gotcha.
So at the court hearing, they have the doctor's report, my report, and then all of the case management reports that have been submitted by the case managers.
And in addition to submitting all that, will you also testify and appear at the hearing and speak to the judge about how things are going?
I am at all of the ongoing civil commitment hearings, and the judge or the magistrate will call on me as needed as they have a review with the respondent about their situation. Some of the review hearings are fairly quick. If the respondent doesn't have much to say, some of them are lengthier discussions about either positive aspects of their treatment, and the review hearings become very supportive, or they're also hearings where we have to discuss with the respondents improvements that should be made in their treatment so they can make progress.
Okay. And at that point, so now we're at 90 days out from when the person was initially committed as an inpatient. I'm sure the answer to this varies, but typically, how long has the person been under outpatient commitment at that point? In other words, how much of that 90 days was typically spent in the hospital versus the community?
Most of that 90 days would be in the community.
Right.
Nowadays, with acute care hospitalizations being shorter and shorter, 2 weeks seems to be the max for someone nowadays to be in an acute care hospital.
Right.
These initial civil commitment hearings are usually held on about day 6, 7, 8, or 9 of that hospitalization. There's a 10-day window in which the hearings have to be held. You have to organize a physician, a hospital, a court, and attorneys, etc. So usually those hearings are held towards the end of that 10-day mark. They then have an additional up to a week, I should say, at the hospital before they're discharged. So most of the time in that 90 days is in the community.
Gotcha. Now, the initial hearing, is that typically held in the courthouse or in a courtroom at the hospital? The initial hearing, going back to the...
Every initial hearing is held at the hospital setting because we need the testimony of the treating psychiatrist. Our court, in my opinion, makes that relatively easy because the court goes to the hospital instead of making the doctor come to the court.
Gotcha. But at the 90-day review, now the person's in the community. At that point, are you in a courthouse?
The 90-day hearings and every subsequent review hearing is done at the courthouse using a written report from the doctor, not live testimony, unless the respondent requests live testimony. That does not happen often.
Okay. So the 90-day review hearing, this is a person who remains under court, or the initial term of the court order is what, like up to a year?
Well, in our court, the initial term is 90 days.
Okay. So
we're basically at the 90-day mark, the treating doctor has to prove that they still fit the statute for outpatient probate. That's the way that our court defends our respondents' civil rights, by making sure that at day 90, they still meet the statute.
I see. So essentially what you're having is a decision to either let the order expire because everyone's happy with the progress the person's made and thinks that they can now take things on their own, or alternatively, you're renewing and putting a new order in place at that point. Have I got that right?
That is correct. Subsequent hearings after the 90-day hearing are generally for 180 days.
I see.
On occasion, sometimes by respondent request because they don't like to come to court, and sometimes due to other factors, we'll extend that next hearing for 360 days or a year. But generally, 180 days is the next period, an ongoing period of civil commitment.
Okay. And in your report to the court, do you make a recommendation as to whether the order should be renewed and the person should remain under outpatient commitment?
No, we leave that strictly to the doctor. There's a very clear understanding that the court doesn't determine whether someone remains under civil commitment. I certainly don't as the probate monitor. The court defers all decision making on treatment and on the decision whether or not to keep someone under civil commitment to the treating psychiatrist. The effort is done in that manner so that we and I, when I meet with the respondent, can direct them to work closer with their treating psychiatrist, both on their treatment, but also on the decision as to whether or not the civil commitment remains intact. It's a nice way that I can push them closer to their treatment provider, because I indicate that I don't make the decision and neither does the court.
Right.
They need to
Right.
work with their doctor.
Right. So you're never the heavy. If they're upset about the fact that it's getting renewed, they're not mad at you.
I'm the heavy on every day but the court day. 'Cause I'm the face of the court that comes to their house, that
Right.
asks them or demands for them to be in treatment. On the court day, it's either the treating doctor or the court that tends to bear the brunt.
Understood. So, you're really in a very unique perspective in terms of getting a sense of how well this program works, because as the liaison, you're really in a vantage point where you're seeing every aspect of AOT, from the initial decision to put the person on it, to the everyday progress on how well they do when they're under it, to the point where they have to come back to court and have it all reviewed. So what is your general sense about how effective this program is? Do you find that most of the people who receive these services under court order benefit from it in a way they wouldn't if there were not a court order in place?
In my opinion, and I haven't added up numbers, but about 75 to 80% really benefit from the outpatient commitment order.
Mm-hmm.
Some of those folks are people who have been in treatment before, fallen off of treatment. They get into the hospital setting. They get back into treatment because of the court order. And those are folks who generally will have their court dismissed at either the 90-day mark or 180 days after that. We have a fair number of people who do very well under the civil commitment order, in the sense that they are in much more stable living situations. They frequently stay out of the hospital for years under the civil commitment order.
Mm-hmm.
It's just that they've never developed the insight to continue their treatment on their own accord. And so their doctor is hesitant and does not dismiss the court order because the person has not developed insight. They may have developed compliance, but they have not developed insight.
Right.
And those people, the order is very effective because it keeps them on a treatment track, keeps them out of the hospital, often out of legal trouble. It just takes them a long time under civil commitment because they haven't developed the insight.
And so with those individuals, will you just keep renewing the order as many times as necessary? I mean, indefinitely, just because you know that as soon as you pull it away, everything's going to fall apart?
We have had some folks under civil commitment for years, yes.
Yeah.
And again, for many of those folks, it's a very effective order. Some of them may feel frustrated because the order continues, but we've had folks with multiple hospitalizations, being homeless, multiple legal encounters, and when they come under the outpatient probate system, they go years without hospitalization, years without legal intervention, etc.
Yeah. Right.
It's effective in that regard. We have, to complete the story on the other end, I'm guessing we have about 5%, maybe at times up to 10%, who even with the outpatient civil commitment just don't comply.
Right.
Those are more the outliers, but those folks exist.
Yeah.
No civil court order is going to get them to comply. I don't have any term of probation, jail time, etc., to hang over someone's head.
Right.
I'm very honest with them and say that if you do not comply with treatment, the moment you stop your medicine, I cannot put you immediately into a hospital setting. I'm very honest about that. I do indicate that if they don't comply with treatment, that their treating doctor is not going to dismiss the court order. Mm-hmm. I indicate that they'll remain under court order for a longer period of time, and that because the court order exists, It is relatively easier to work with a hospital and our crisis team to get someone into a hospital when they need to, because
Right.
they're already under a court order and they're already deemed someone who's not ready for voluntary treatment.
Yeah, that's such an
But we
important
have
point.
some folks who just walk away,
Hmm.
and we
Yeah,
just have to wait till the next time they decompensate and end up in the hospital.
yeah.
So,
I'm glad you make that point because as we promote this concept around the country, I try very hard not to oversell it. It's not a magic bullet. Of course, there are going to be people for whom it will not work, but you're dealing with a very challenging population, and the fact that it works in so many cases, the fact that it helps lots of people who would be in really bad situations if they didn't have this in place, for me is, and it sounds like for you, is reason enough to do it. And you can't let the fact that you're not helping everybody prevent you from helping some people.
I,
Um,
I agree.
right. Um, you talked a little bit about the consequence of the court order, and you're upfront about the fact that you cannot actually punish a person. You cannot say immediate automatic hospitalization as a consequence of your not following the order. But it does sound like there is some process, there is some consequence that takes place, even if it's not punishment in the form of hospitalization or contempt of court. People do understand that if they violate their court order, something will happen, right? I mean,
They understand that if they violate the court order and don't get treatment, that one, again, they won't have the probate order dismissed, and two, I do tell them that it is easier and quicker to get them into the hospital when needed because the court order is already in place. That
right,
makes it easier for the crisis team to pick them up. It makes it easier for the hospital to re-hospitalize them. They don't have to go through another court hearing. They just have to appeal to the court on a written report to change the court order from outpatient commitment to inpatient commitment.
right,
Um,
right.
I indicate to people under community probate orders that I can't force them to live in our group homes. Our group homes are voluntary. I
Yep.
indicate that I'd like them to live there, but I can't force them. I'd like them to get treatment from a certain agency and work with case managers, but I can't force them. I try to be very honest and upfront about that. At the same
Right.
time, trying to work with them or negotiate with them to follow up with a plan that I think will help them be stable.
Hmm. And do you find that people tend to understand their relationship with the program as one that is non-adversarial, that is everybody's on their side, and it's not a matter of twisting their arm into making them do things that are going to be bad for them, but in fact is about trying to support them and help them? I mean, do the patients tend to understand it that way, or does that vary?
It varies. Uh,
Yeah.
Many of the respondents see me as helpful. Many of the respondents learn to trust me over the years. I'm I'm fairly constant in their life. I'm seen at the group homes a lot. They see me at court hearings. I take their phone calls. Many of them have my cell number. I mean, I try to be as available to them as possible. I have other people who comply with my order, but I don't think would friend me on Facebook.
Right.
But they do comply with my order. They will meet with me, and they will work with me until their court order is dismissed. And then I have again a smaller percentage of people who are outright hostile to me and don't want to meet with me or refuse to meet with me.
Yep.
So it runs the gamut there too.
Yeah. Interesting. Well, whether every one of your patients appreciates you or not, we certainly do, and we think you're doing terrific work, and wish we could clone you. Put Nick Schrantz's all over the country. But I really appreciate the time you took to explain your role with us today. And if anyone has any questions raised by the discussion we've had, I encourage anyone watching this to get in touch with me through TAC, and we'll try and get some answers from Nick. So thanks again for all you're doing and for this conversation today.
Thank
Really
you,
appreciate it.
Brian. Take good care.